So welcome back, members. So today we will be doing legal drafting and legal writing and drafting as per the paper that was done in 2015. Basically, we will start with question 1, then proceed to answering the full paper and addressing any current affairs. So section A, it says that during the period of the monopoly of the newly reformed Telecom Kenya, previously known as Kenya Post and Telecommunications Corporation, in the telecommunications sector, an applicant for a private telephone connection was subjected to very rigid procedural rules. One was required to disclose, among other things, personal details such as postal and physical addresses and their national identification number. Towards the end of 1990s, the telecommunications sector was liberalized. As in most other sectors, the consequence of this liberalization was to open the market to other players and competitors. It will appear that there were no adequate preparations for handling the plethora of activities that had been witnessed in the sector. Several companies are now fiercely competing for market share in the mobile phone industry. It is estimated that there are close to 18 million mobile phone subscribers in the country. While the focus of the government has been on licensing and regulation of the sector's market players, little attention has been paid to the users of mobile phone services and products. There have been cases of criminals buying subscriber identification model SIM cards and using them to execute criminal activities. Mobile phones are now used by child abductors and kidnappers to extort money from their targets. Cases of ordinary individuals using temporary lines and SIM cards to make anonymous calls or send offensive text messages via SMS to abuse or threaten others are still rampant. Mobile phones are also reported used to aid cheating by candidates in examinations. So questions have emerged on who should own a mobile phone line and whether some restrictions ought to be imposed on the users. Consequently, the 2025 regulations on registration of SIM cards have been formulated. So the question required the student to draft salient points of the government policy to give effect to the regulations and be prepare appropriate legislative drafting instructions. This is a question that has been asked in the current 2026 April paper. There was a question on drafting legislative instructions. So what is it and how will students be able to navigate such situations? Then you have draft a bill for introduction in Parliament with due consideration of rights and obligations, supervisions, penalties, and transition issues. So remember, this year we have a current bill, the Artificial Intelligence Bill of 20. I'll confirm the year. So when we will be analyzing the drafting part of this answer, we must have a look at what the Artificial Intelligence Bill also appears. We will have a look at various provisions of the bill, so that it is amongst my top predictions where we'll be told to draft a bill for the AI. I predict such situation can happen. So question 1, draft salient points of the government policy to give effect to regulations. So basically, there are some riders that a student ought to take when it comes to regulation questions on whether to draft a regulation or an act. Okay, so when it comes to that situation, remember, for a regulation you must have the parent act being cited in the question, as we saw last in April 2026 paper, a receipt paper. So if there is no parent act that already contemplates SIM card registration and offences, then the regulations will be void. So that is one key angle for you to distinguish whether you're drafting a regulation or a bill of parliament. So moving on swiftly, I decided to draft policy booklets that the examiner will have to look before he awards you the marks. And in this situation, if it is a government policy, you must have the purpose, you must give the scope, you must give the safeguards, enforcement, and accountability. And as we saw in other papers, at times you can say whether the proposal will have the policy will have financial implications. That is also a point on its own. So if you look at the marking scheme, So this is why you have the objective of the government policy is to target public safety and consumer protection. Then if you look down at the point number 2, where we have strong privacy and security controls. This is why you apply now your creativity to give the exact scope of application of these regulations, and one of the scope that is being targeted is where you are using security controls by these policies that you want to pass to the government. Then basically I have addressed the marking points, so the other points were just additional points that attempted to give meat to the various steps that I have outlined above. So you as a candidate, you must know if you're dealing with any government policy, the examiner must see the purpose of that policy, the scope of operation, the safeguards that you want the relevant body to incorporate, what is the enforcement mechanism and accountability. Enforcement mechanism, the regulations will be dependent on the regulations that are going to be drafted, then the regulations still get their power from the parent act. So that is it. The question required 5 marks. So what amounts to legislative drafting instructions? Okay, so this is where the examiner expects to see that you have a policy problem and a mischief that you want to cure. Remember, a legislative drafting instruction that was tested last year, not last year, in this year's 2026 April receipt paper, the question carried 5 marks. So if a legislative drafting instruction can carry 5 marks, then there are some key details that a student should not miss whenever they are drafting instructions to anyone. Okay. So one of the key identifier that I was able to identify is where you have the policy problem and explain the mischief that you want the policy or the regulations that are coming to be drafted to sort. So policy problem is 1 mark. Then what is the legal basis of what you are recommending? So remember, the legal basis in this situation, you have the regulations, and then we have an amending bill to strengthen Part 3 of the Telecommunication Services on SIM registration. Okay, so the examiner expects to see the legal basis of your drafting instructions. And then lastly, you have core design choices to implement. Remember, we have seen that for a good drafting instruction to be deemed good, the same must have a way of implementation. You should at least try as much as possible to bring implementable solutions. So in these situations, we are expecting to see choices like re-registration and deactivation rules and agent licensing. So if an examiner sees that you have a good way of recommending for various implementation angles, then you will see that you are actually reasoning when it comes to your application. Then lastly, I said that when it comes to the bill, because part 3 of the question told students to draft a bill for introduction in Parliament with due consideration of rights and obligations, supervision, penalties and transition issues, and the question carried 7 marks. So what is expected of a student when it comes to this part? So it is at this part that I said I will project the AI bill so that we see exactly how the framers of the AI bill have done it. We get to see the language that has been used and the various, the various tools of interpretation that they have used when it comes to drafting this bill. So let me share the screen that has the bill, because we can't ignore the same as a prediction for this year. So before you have the Kenya Gazette Supplement, Senate Bill of 2026, that was introduced in Parliament, and the same is dated 19th February 2026, being the date of introduction. Then this is a bill for introduction into the Senate, the Artificial Intelligence Bill 2026. So if you look at the various parts of a bill, we have what we call in quotes the table of contents, and briefly we can discuss the table of content to avoid any situation where a student will think that we are cramming. So if you look at the table of content, the bill must have a title. It must have an arrangement of clauses, various clauses that are required. Then it has some parts. Then there is a short title, interpretation part, and the scope of artificial intelligence. So this narrows down to tell you that if you never drafted a good government policy, as we saw above, and the government policy had a weakness in that you never gave the scope of your recommendations to the government. So then we will say that you don't know that a scope of a certain bill is very relevant when it comes to its design. Then if you look at part 2, we have now the establishment of the Office of the Artificial Intelligence Commissioner. So another key takeaway that we can say is that after part 1 of every bill, we must have a body, we must have an office that has been operationalized, so that to make sure that your recommendations or the scope of the artificial intelligence bill will be governed accordingly by an established office. So remember, we saw that a good legislative drafting instructions should have a way of implementation. And now when you draft part 2 of the bill and incorporate an office of the Artificial Intelligence Commissioner, then the examiner sees you are able to correctly define what a legislative drafting instruction is, because you have directly touched on implementation of the same. So inside part 2, we usually have the establishment of the office, then appointment of the officers for that office, then qualifications of the commissioners in charge of the office, then you have oath of office, vacancy, and when it comes to removal, the functions of the office, powers of the office, staff of the office, remuneration of the Artificial Intelligence Commissioner and staff, and delegation by the Artificial Intelligence Commissioner. Okay, then you have protection from personal liability and confidential agreement. The reason why I want us to understand what forms part 2 of every bill is that at times you will encounter a situation where the examiner will tell you to draft an enabling office or body to govern a certain bill that is coming to be in operation. So if you don't really know what part 2 of a bill entails, then you are likely to fail. So there is an office, and that office must have appointees. Then those appointees, for them to be appointed without discrimination, they should qualify for something. Then they should take an oath of office. Then they know that maybe some people can die while they are in office, so there is a provision of vacancy. Then at times a person can be removed from office, and then we have what are the functions of the office and powers of the office, and who amounts to staffs of the office, and then how will be their remuneration be conducted. Then if you look at part 3, we have the establishment of the advisory committee on artificial intelligence. So this is now where every bill has its own part 3. Okay, depending on various aspects. But part 4, when it comes to financial provision, this is also a very key part, because some bills have an effect to what we call as the money bill, and they will require funds allocation for the office to be operational and some aspects of the same to be operational. Then you have part 5 of the governance of artificial intelligence. Again, that is a separate angle of it, where because every bill will come with its own uniqueness. Then we have general provisions. This is where the examiners have tested students over the years to be keen on. Do you know how to draft an offense and create a penalty to that offense? Do you know how to create regulations inside a bill? Okay, these were the examiners person to the numerous studies that we have conducted with you. Will say that actually, even in the question that is before you, the examiner expects a student to draft a part of a bill where the offenses are involved. Okay, so how will you structure your drafting so that the examiner sees that you actually know what you're doing? Okay, so look at the long title, the Artificial Intelligence Bill 2026, being a bill for an act of parliament to provide for the regulation and governance of artificial intelligence in Kenya, to establish the office of the Kenya Artificial Intelligence Commissioner and for connected purposes. Enacted by the Parliament of Kenya as follows. Check the use of the long dash, because we have seen situations where the examiner now tells a student to redraft various sentences to form a flowing paragraph. Okay, to form a paragraph or a certain part of a bill. So take note of the use of symbolizations. Then briefly, part 1, this is how it appears. Look at the short title. This act may be cited as the Artificial Intelligence Act of 2026, and in this act, a long dash is used. Check at how the various wordings when it comes to the interpretation of some words inside your bill is used when it comes to semicolons and not semicolons, closing and opening as speech marks. So that is the use. Also be keen on how a semicolon is used at the end of every paragraph in the interpretation part, because these are the nitty-gritties that the examiner in legal drafting will be looking at. There is a long dash, there is some semicolon, there is an opening and closing many punctuations. Okay, so that is it. When it comes to the interpretation part, remember you interpret only the words that are likely to cause a confusion. Then look at the last paragraph and the use of the full stop. Then we go to the objects of the act. We notice that there is the use of a semicolon, there is the use of a letters, and then there is the use of a long dash. Okay, so generally we have first analyzed how the structure of a bill will appear. Okay, and that is crucial, because if you have been told to draft and you don't know how the bill is to be structured at the head, at the back of your head, there is a likelihood that you will mess up every other paragraph that you are doing. Then I told you to also be keen, because in a situation you have been told to draft various offenses and give penalties to it. So you must jump directly to the offenses part so that we see the language that is used when somebody is trying to create an offense. Do you give reference to the main act, to the parent act, if it is a regulation? Okay, this is where the examiner will likely test. Part 6 on general provisions. Look at clause 35. Okay, subclause 1. A person commits an offense if the person. Okay, before I start overthinking, how do you spell out various parts of a bill? This is very crucial, because you will be told by the examiner next time to amend a certain provision of a bill. Then you will be citing paragraph, sub, clause, section. Let us see what is the language. What is the language used in reading parts of a bill, so that you can guide the examiner. Amend clause 2 and replace. Amend clause 2 or delete clause 2 and insert thereof immediately after subclause or clause 2. Okay, those are the technicalities that the examiner will test. How do you read a bill? How do you read a bill? Well, let me specialize in Kenya. Okay, I'll confirm that later when we will have the second session, but you must know the various parts and languages used. Naming parts of a bill in Kenya, e.g. clause, let us see whether we can identify from the salient features of a bill. What is a bill? Good. At least this one will help us. Okay. Let us see. Arrangement of clauses. It gives an indication of the arrangement of the parts, sections, and subsections of the bill. Okay. Okay. So let me leave that part for research, because we must understand how to read policy formulating process. this is the marking scheme of whenever you're being told to draft policy to advise the government. So this is a generic policy framework, and it must contain all the following. It must have the introduction, situation analysis, challenges or problem or issues to be addressed, analysis of the existing legal framework. This is where we said that you must have a legal basis. What are the strategies for implementation? Who are the actors? What is the target audience? What is the monitoring and evaluation mechanism? What are the review measures? What is the conclusion and way forward? And what is the provision of a legal instrument for its operationalization? Then what are the stages in the policy formulation process? We have the policy initiation, we have research, we have negotiation and public participation, we have finalization of the policy, and then we have parliamentary or county assembly approval, and then assent, passing by the respective house. Then we have publication, and then we have a draft bill. Okay. The policy is also known as the white paper and often forms the basis of legislation. If it is determined at the ministerial level that a new law is necessary to achieve its objective and aid implementation, the concerned MDA, the ministry, will commence the process of drafting the bill to give effect to policy directives. In its early stages before a law is tabled in the House, it is called a legislative proposal. Once it has been so tabled, it is called a bill. So we move from a legislative proposal to a bill. As it has been set out, not all policies end up requiring legislative instruments to be implemented. Such policies are known as self-executing policies. This means that they are effective immediately without the need for ancillary legislation. That is the breakdown. What is a legislative sentence? This is the arrangement of words to express a command or state a prohibition. So a legislative sentence must contain So I was discussing on what is a legislative sentence. So this is the arrangement of words to express a command or state a prohibition. So the sentence, legislative sentence, must contain 1. The legal subject, i.e. the person to whom the law applies, and the legal action, the law which is to apply, and the circumstances in which the law is to apply. So in short, the legislative sentence states how, the manner in which the law is to operate, and what is the nature of the legal action, and when, the condition under which the law is to operate, and where, the circumstances in which the law will operate, and who, the legal subject, the person given responsibility, or
ile pesa uliambia kama tuongea hapo kwa
hii kitu shua benda kwenda.
Sawa. Ndio. Aise mimi nilikuwa kitambo kama kwenda noma. Sawa basi. Sawa.
So what amounts to a proper legislative sentence is where we have the how, the manner in which the law is to operate, the nature of the legal action, the conditions under which the law is to operate, the circumstances in which the law will operate, and the legal subject, the person given responsibility or on whom is placed an obligation or prohibition. So you must see the legal subject, and then why, the policy considerations of the law. That is what amounts to a legislative sentence. Then, what is language and syntax? So these are basically various questions that an examiner can ask that carries 5 to 3 marks. So in drafting, it is important to observe the following language and syntax rules. You must have familiarity, where the drafter should use short, familiar words and phrases. Brevity, a good drafting uses short sentences which communicate only one message. Then consistency, the same word should be used to express one meaning within the bill. Then spelling, the bill should demonstrate consistency in the spelling of the words recurring in it. And then standard language, where we have the drafter should utilize the standard form language of the drafting office. In Kenya, this is called the House Drafting Style, whose custodian is the office of the AG. And then clarity, a bill should be in clear, simple and precise language. The draft bill should be clear about the audience it addresses, those it regulates, and those that are responsible for its enforcement. Then harmony, the draft should correlate with other existing laws on a similar subject matter and have logic, where the material in the proposed law should be organized in a logical manner with the same subjects dealt with separately and sequentially. So as a key takeaway, we have familiarity, brevity, consistency, spelling, standard language, clarity, harmony, and logic. So at times an examiner will tell you to draft a legislative plan. What is it? So a legislative plan is a document which provides the drafter with the basic outline of the legislation, raising issues and possible content of the proposed legislation. It is the drafter's answer to drafting instructions. Okay? So this is why you are answering the drafting instructions. And it includes the following. Whenever you are told to draft a legislative plan, you must have objects of the required law. You must have a proposed title. Although this is usually provided by the instructing agency, the drafter may also develop a title that captures the overall objectives of the bill. Then you have substantive issues to be covered by the law, such as, for example, if establishing a body, one must propose the relevant body, the qualifications of the people, the procedure for appointment, including other substantive issues, such as the function and the powers of the body, as we saw. Then, a legislative plan also requires implications of the proposed law. So this provides making the following considerations. Have you analyzed the existing legal framework to check if the proposed law has any impact, or vice versa? Have you checked on the constitutionality of the proposed law? And have you done an analysis of the required standard of the law, such as the competence of the instructing organization, effect on fundamental rights, retrospective application? This is permissible in civil but not in criminal matters. Then introduction of extraterritorial jurisdiction, which may not be permissible. Okay, so then we go to the various stages of drafting a bill. So when you're drafting a bill, a drafter with full instructions of the instructing department follows the path outlined below to prepare the desired drafting legislative instrument. So they receive and review instruction, they conduct a factual background check, then when necessary they seek clarification from the instructing department, and then the drafter must, arising from the consultation, make a draft that is clear on the policy intentions of the instructing department. Then they undertake comparative research to ensure that the draft legislative instrument benefits from international best practices. Then they devise ways around any problems that may arise out of the proposal and harmonize any departmental conflicts. Then in case of drafts that are subject to parliamentary or county assembly committee reviews, draft and incorporate any amendments, and then certify that the minister and cabinet secretary has powers to make subordinate legislation and that the same are accurate and in line with the delegated authority, then ensure that the draft legislative instrument conforms to the letter and the spirit of the law. Then, what are the salient features of a bill? This one we have discussed, and our main target was how we will name various parts of a bill. Okay. This is it. This is it. Naming conventions in a bill. The conventional way of referring to units below the section level is to use the smallest unit of the text. So this is in an act. So they have given us a situation in an act. So whenever we are naming or amending some parts of an act, we will say that amend section 12, subsection 12(1), paragraph 12(1)(a), and subparagraph 12(1)(a) Roman 2. So we begin from the section, subsection, paragraph, then subparagraph. That is when you are naming parts or amending parts of an act. Okay. So all these have various notes. So that is it. So let us go back to reading out our general provision. So this is how it will appear. When the examiner tells you to draft an offense and give penalties to it, and then this is being used to amend or be inserted in a bill, as we have seen in the current question that we are answering. So clause 35, subclause 1, but I'll confirm. A person commits an offense if the person the use of the long dash A deploys or operates an artificial intelligence system classified as an unacceptable risk under section 25, except in circumstances prescribed by regulations. Then B deploys a high-risk artificial intelligence system without conducting the required risk assessment or implementing mitigation measures prescribed under section 26, then fails to comply with disclosure or transparency obligations under section 28, and participates in a regulatory sandbox under section 29 without adhering to the prescribed conditions. So that is the tone used when it comes to giving an offense. Because it is a bill, you must make reference to the to various sections of the proposed act. Okay. So now look at how the offense provision is being drafted. A person who commits an offense under section 34 is liable, comma. So there is use of a comma when you are introducing the first sentence when it comes to the penalty provision. And that sentence is starting with a capital letter. So a person who commits an offense under section 34 is liable, comma, on conviction. Don't forget the use of the long dash. A. In the case of an offense under section 34 A, B, D, E, G, or I, Roman 1, to a fine not exceeding 5 million shillings or to imprisonment for a term not exceeding 2 years, comma, or to both. use of semicolon and. So this is very critical. Whenever you're separating various sections where you're making reference to, you use commas. Then use the terms find not exceeding a certain amount. Then the use of or, okay, not exceeding 2 years. Then you can see there is a use of a comma before you introduce the both perspective or to both. Okay, then semicolon and. Remember the use of and. So the use of and is for a conjunctive test. In the case of an offense under section 34C, F or H, comma, to a fine not exceeding 1 million shillings or to imprisonment for a term not exceeding 6 months, comma, or to both. Then there is another aspect that the examiner expects to see, where the offense is committed by a body corporate. Every director, so there is a comma, every director or officer of the body corporate who had knowledge of the commission of the offense and who did not exercise due diligence to ensure compliance with this act shall be guilty of the offense. Okay, shall be guilty. So there are some elements that the examiner expects to see from a candidate. Do you know that a body corporate can also be cited when it comes to making reference to it, and when you are making reference to the directors who operate inside the body corporate? Okay, then how do you make reference to when you are giving a certain person powers to carry out provisions of the act? So the cabinet secretary shall, in consultation with the artificial intelligence commissioner, make regulations for the better carrying out of the provisions of this act. That is critical because if failure to give the powers So thank you for your indulgence. So we had finalized on the part that you make reference to a commissioner and you give room so that his powers shall be used in consultation with the cabinet secretary for the better carrying out of the provisions of a certain act. Failure to do that, then any action that will be purported to be done by the commissioner will be ultra vires. So now let me share out the question paper. So question 2, good legal writing is best understood as writing that aids legal actors in making decisions in the course of their professional duties pursuant to Nzioki. Assess the relevance of this statement with practical examples. And then, what is the impact of plain English in legal writing and drafting in light of the work of a practicing advocate in Kenya? 8 marks. So first start with the relevance of Nzioki's statement that good legal writing is best understood as writing that aids legal actors in making decisions in the course of their professional duties. So practical examples of what a decision aiding looks like, because we have been told to use practical examples to answer this question. A demand letter is where a good decision aiding is used. So a good one lets the recipient decide whether to pay or settle or defend by stating out facts, legal basis, remedy demanded, deadline, and consequences without threats or vague accusations. So that is a good example where a good legal writing will help a legal actor to make a decision. Then look at pleadings. A good pleadings let the court decide the real issues early when it comes to jurisdiction, limitation, cause of action, and relief. So bad pleadings bury the cause of action, overplead facts, and invite striking out and adjournments. So then we have submissions. It's also another decision aiding criteria. So good submissions give the court a decision path because we have the issue, rule, authority, application, and orders are being sought. This reduces judicial labor and increases persuasiveness. In April 2026 papers, there is a question in civil litigation that requires students to draft submissions. Okay. Then 4, draft a contract clause is also another area where a decision from use of good English, good legal writing skills is appreciated where you are drafting a contract, because if you specify the trigger and notice method, time to cure, and the effect of termination, you reduce interpretative dispute, and courts will tend to enforce clear processes rather than invent alternatives. And then another angle is where we use board or client advice memos, because decision aiding writing tells the client one options, risk rating, cost and time, and evidence needed. Then regulatory response. Good writing maps each regulator allegation to a factual answer and annexures, so the regulator can decide compliance without follow-up letters. And then we have court orders and consents. A good consent or order is operational. It identifies parties and amounts or timelines and default consequences and cost and mode of compliance, so that execution and enforcement is straightforward. Then what is the impact of plain English in Kenyan legal writing and drafting for practicing advocate? So plain English improves the speed, accuracy, client outcomes, and enforceability. It reduces disputes and cost by making obligations and remedies easy to understand and apply, while still allowing technical precision where necessary. Then what are the practical impacts for an advocate? Client comprehension and informed instructions. So I was saying that if you look at the practical impact for an advocate, we have client comprehension and informed instructions. We have fewer disputes and fewer interpretation fights. Then we have better litigation efficiency. Then we have stronger negotiation leverage, and we have compliance and operational usability. And then we have good evidence quality and regulatory defensibility and professional risk management, because it reduces negligence exposure. Okay. Then read the other question that says that passive voice is not forbidden. Active voice is better and easier to understand and is therefore preferred in legal writing. Honeycomb. Access this statement with examples, and then you are required to edit the following passage to eliminate passive construction, and the same required 7 marks. Okay, so the original passage was that the Sunday Magazine feature was written by John Dongo. He argued that the National Assembly's domain must be protected from the courts in order to promote the doctrine of separation of powers. He argued further that we are in danger of the agenda of the National Assembly being set by an overzealous judiciary, and hence, as enshrined in our Constitution, curtail the doctrine of separation of powers. Okay, so we start with the first question. Assess the statement that says passive voice is not forbidden and active voice is better and easier to understand, and give examples. So the default rule is that use active voice because it names the actor and action, because it says that the actor must do Y, which reduces ambiguity and litigation risk. But passive voice is useful when the following is involved. When the actor is unknown, you can say the document was lost because you don't know the actor, you don't know the person who lost that document. And where the actor is irrelevant, okay, payment must be made within 7 days. It is irrelevant to cite the actor. Then you use passive voice when you deliberately want to focus on the object and result. This is common in procedural writing in that the application is dismissed. Okay, your main focus is the object and result. So we also have some drafting risks in that passive voice can hide responsibility. Who must act? Who breached? This is very dangerous in contracts and compliance manuals and notices and pleadings because you are leaving a room that should have disclosed responsibility. Okay. So Kenyan courts have consistently said that they will not rewrite contracts. So unclear drafting can sink you in. And courts criticize misinterpretation that effectively rewrote a contract. Okay. So you are required to assess honeycomb statement with example. So passive voice isn't wrong, but active voice is usually clearer and preferred in legal writing because it identifies the duty bearer and the breach point. Then the governing rules we have discussed above. Then the examiner expected a student to also cite with examples. This is where the students drew the line and ended up scoring 1 and 2 marks. So a good example is where we have contract obligation. Okay, contract obligation. Okay, contract obligation. So when you are using the passive language, you say that rent shall be paid on the 5th of each month. Who pays? Tenant implied, but it is not stated. Active voice is where you say the tenant must pay the rent on the 5th of each month. Okay, so these are the examples that show why active voice is better. Who pays? It is the tenant. Then now go to the notice clause. A passive voice reads, notice may be served by email. This exposes one to by whom, to whom, so there is uncertainty. Okay, so you state that in active voice, either party may serve notice on the other party by email to the addresses in Schedule 2. Okay. 3. Compliance responsibility. Passive voice is where you say all licenses must be obtained before operations commence. Then the compliance responsibility. Responsibility is tied down. Responsibility is tied down to the contractor. The contractor must obtain all licenses before operations commence. Okay. Then when passive voice is justified, where we have an actor who is an unknown or irrelevant to state the actor. The premises were broken into on 12th May 2026. But when it comes to the formal court style, you say the appeal is dismissed. Okay. So the examiner expected a student to give out scenarios where you are proposing that the active voice is irrelevant and give various situations where you can use passive voice and the same is to be justifiable. Where the actor is unknown, or it is irrelevant to state the actor, and where your main goal is the object or result, like how it is being used to in court situations, like the appeal is hereby dismissed. So we have also edited the previous Sasam. Yes? So apologies for that. So I was saying that I have edited the first paragraph to what is before you. So if we do a distinction between the two, the first sentence has been changed to John Ndongo wrote the Sunday Magazine feature. How did the first sentence appear? The Sunday Magazine feature was written by John Ndongo. So I have started with the actor because the question now requires you to eliminate passive constructions. That is one. He argued that the Constitution protects the National Assembly's domain from court interference to promote the doctrine of separation of powers. Who argued? Okay, John Ndongo. Okay, he argued. So he argued that the National Assembly's domain must be protected from the courts in order to promote the doctrine of separation of powers. That has not been touched. Okay. He argued further that we are in danger of the agenda of the National Assembly being set by an overzealous judiciary, and hence, as enshrined in our Constitution, curtail the doctrine of separation of powers. Okay. He added that an overzealous judiciary may set the National Assembly's agenda, and in doing so undermine the doctrine of separation of powers enshrined in the Constitution. Okay. May set the National Assembly's agenda, that an overzealous judiciary. Okay. Who is the actor? The overzealous judiciary came before the National Assembly. Identify and explain the functions of 5 key parts of a demand letter. On 10th December 2010, Ivy Wanjiru entered into a lease agreement for residential apartment number 10, Baraka Villas, at a monthly rent of 65,000. Pursuant to the said agreement, Ivy paid to the landlord a sum of 130,000, being 2 months rent deposit, and the landlord acknowledged receipt of the same. It was a term of the agreement that either party could terminate the lease upon giving the other 2 months' notice. Pursuant to this clause, Ivy gave notice to terminate the lease to the landlord on 15th August 2014, and receipt thereof was duly acknowledged. In breach of the lease agreement, the landlord Professor Kamau Ngugi has refused to refund the 2 months rent deposit to Ivy. Ivy has approached you as an advocate to act for her, and you have determined that she has a reasonable cause of action. Draft the appropriate demand letter. Okay. Draft the appropriate demand letter. So you start with the 5 parts of a demand letter. So this is where we have parties, reference, and authority to act. This identifies the claimant, the recipient, the transaction, and that you act for the claimant. This eliminates wrong party and wrong contract defenses. Then you have brief facts and timeline. Set out the key facts chronologically. This is where you state the contract details, payments, notices, breach, so the recipient can verify and decide quickly. Then state the legal basis and the cause of action. Okay. This states the contractual and statutory duty being breached and why liability arises, e.g. breach of lease, covenant to refund deposit, and unjust enrichment. Then what is the remedy? This specifies what you want and the amount and interest if claimed and the amount of payment, and avoids ambiguity on what will settle the dispute. Then 5, the deadline and consequences of non-compliance. This gives a clear period to comply and states next steps, e.g. suit filing, cost, interest, and costs often consider pre-action conduct, including whether demand was made in court's discretion. Okay, so you have been told to draft a demand letter involving Ivy Wanjiru versus Professor Kamau Ngugi. So you have the letterhead, you have the date, you have to whom the demand letter is being addressed, then you have the title. So the title can capture what you want briefly. Okay, so this is how you will draft it. We act for Mrs. The title, demand for refund of rental deposit. In regards to apartment number 10, Baraka Villas, this number, plot number. We act for our client, Miss Ivy Wanjiru, our client. We write on our instructions that on this date, these are the brief facts. Upon execution of the lease, now this is the cause of action. The lease permitted either party to terminate. Okay, in compliance, you have breached. Despite lawful termination, you have refused and or neglected to refund the deposit. Okay, so you have demanded, then there is deadlines. Take notice that unless payment of this amount is made to our client within 7 days from the date hereof, we have firm instructions to institute proceedings against you without further reference, seeking the principal sum, interest thereon, and costs of the suit and incidental expenses. Payment should be made to this number, then you sign off. So I beg your indulgence so that I break this session into 2. And because I'm breaking now and then, So in a few, then I will project part 2 of it.